Next, we're going to turn to securities regulation. And both federal and state laws regulate the offer and sale of securities, but we're going to focus on the key federal statutes and regulations involved in regulating securities. And the primary federal statutes are the Securities Act of 1933, which is called the Securities Act, and the Securities Exchange Act of 1934, known as the Exchange Act. Sometimes they're also referred to as the 1933 Act and the 1934 Act. Now, the Exchange Act also created the Securities and Exchange Commission, or the SEC, to oversee the regulation of federal securities laws. States have also passed their own laws, which are referred to as blue sky laws. But as I said, we're going to focus on the federal ones. Now, the Securities Act defines securities broadly to include notes, stock bonds, stock subscriptions, voting trust certificates, limited partnership interests, investment contracts, pretty much everything designed to cover both traditional securities such as stocks and bonds and unconventional transactions where the underlying purpose is to provide investment income. So if you purchase something thinking you're going to get more money later, chances are it's a security. So really what courts will look at is, does it count as an investment contract? And there was a famous case, SEC versus Howey Company, in 1946, which defined an investment contract as an investment of money in a common enterprise when the purchaser is led to expect profits solely or primarily from the efforts of others. So if you hear those criteria, that's very broad. So it's basically anything you would invest in where you're looking for profits based on the activities of someone else counts as a security. So what counts as Securities Act registration and regulation? First, registration. So Section 5 of the Securities Act provides that securities cannot be offered or sold unless they've first been registered with the SEC, which means that you file a registration statement and it contains information about the securities to be registered as well as the company. You also have to provide a prospectus, which is a document that contains information that has to be given to investors before they purchase that security. And so it sort of discloses lots of information about the company. And it's designed to contain all of the information that an investor needs to evaluate the security, and in particular the risk that that security might have, because the point of the SEC and the point of the registration and the regulation is to make sure that the investing public knows the risks that it's taking before it takes them. So the Securities Act imposes strict rules on companies that are in registration, that have these registration requirements. And in particular, the Act limits the type of information companies may disclose to the public. And again, they're trying to reduce the potential for fraud, make sure individuals have informed information about the companies and understand the risk that's involved, making sure all of the information is accurate, and so forth. Once a company issues its securities pursuant to the registration process, it's referred to as a public company. Now, if you violate the registration process, the Securities Act imposes various remedies. Section 12A1 of the Securities Act imposes civil liability, which means anyone who fails to register a security that should be registered can ultimately be held liable for a civil penalty. Section 11 of the Securities Act imposes civil liability for material misrepresentations or omissions in the registration statement. And here the plaintiff only needs to show the existence of a material misrepresentation or omission. The plaintiff does not need to show reliance on it. The plaintiff doesn't need to show that she even read it, just that there was a misrepresentation in it. And liability extends to the issuer, its directors, the chief executive officer, the chief financial officer, the underwriter, and any expert, which includes accountants and lawyers, anyone who renders a professional opinion or certification in the registration statement. Any of those can be liable, and the issuer has strict liability here, which means that it's not about whether somebody was negligent or did something wrong. The question is, was there a misrepresentation? And if there was, there's liability. Now, there is one way that the issuer can avoid liability, and that is if she can show negative causation, which means demonstrating that whatever damages the plaintiff has, those damages were caused by something other than the misrepresentation or the omission, such as, for example, general market conditions. The stock market went down. It had nothing to do with this thing that was misrepresented, that sort of thing. Now, I said that liability extends to the issuer, directors, chief executive officer, et cetera, accountants, lawyers. But some of those defendants, not the main issuer, but some of the other defendants, can raise a due diligence defense. So if the defendant is an expert, and if the statement occurred in an expertised portion of the registration statement that are certified by an expert, then it may be that the expert only has liability for the portions she certified, but not for other things. And so in this context, to establish a due diligence defense, an expert has to demonstrate that after reasonable investigation, she had no reasonable basis to believe that the statement contained any material misstatements or omissions. People who are not experts must establish the same due diligence defense with regard to the non-expertise portion of the registration statement. However, for the expertise portions, non-experts don't have to do anything because the idea is that they relied on the expert to review that portion of the registration statement, and they're entitled to rely on that expert. So if you're not an expert, you either have to provide a due diligence defense to registration errors in the non-expert portion of the registration statement, or you need to rely on the expert. And if you are the expert, you're only responsible for the parts that you paid attention to, and you can raise a due diligence defense there. Now, Section 12A2 imposes civil liability for material misstatements or omissions in a prospectus or oral statements that relate to a prospectus. And here, liability extends to any of the statutory sellers, and the plaintiff, again, doesn't have to prove reliance or causation. The seller can avoid liability, again, by showing negative causation. As I mentioned before, that the damage would have been caused anyway, even without whatever the prospectus statement might have said. And the seller can also avoid liability if the plaintiff knew that the statements in the prospectus were not true at the time of the purchase, or if the seller did not know and could not reasonably have known that the statements were not true for whatever reason. Now, the Securities Act exempts certain securities from regulation. I mentioned earlier that the definition of securities is pretty broad, but there are some that are outside the realm of regulation. So securities issued by the federal government, state governments, or any of their subdivisions, securities issued by a charitable organization, securities issued by banks or savings and loan institutions. Those are regulated separately. Securities issued by a bankruptcy trustee. Securities issued with a maturity date of less than 9 months, so very, very short-term kinds of instruments. And then securities that are regulated by other federal laws are not generally regulated by the Securities Act. Insurance or annuity contracts are not regulated by the Securities Act. Again, they're regulated separately. and securities that are issued in transactions that occur significantly within one state are not regulated by the Securities Act. If you'll recall earlier, Congress isn't allowed to regulate transactions that occur within one state because Article 1, Section 8 only allows Congress to legislate in areas of interstate commerce, not intrastate. And so if the securities issued involve transactions that occur only within one state, that would be up to the state to regulate. But it's exempted from the requirements of the Securities Act. The Securities Act also exempts certain transactions from registration. Section 4 of the Securities Act exempts transactions by any person other than an issuer or underwriter and any transaction that does not involve a public offering. An underwriter is essentially any person who's helping the corporation distribute its shares. The question of what counts as a public offering, though, takes a little bit more explanation. So if it's not a public offering, it's what's called a private placement. In a 1953 case called SEC versus Ralston Purina, the Supreme Court defined a private placement as a sale to persons who don't need the protection of the securities law. Well, who is it who doesn't need the protection of the securities law? Basically, sophisticated investors. So the way to think about it, I think, is if you are selling your security only to sophisticated actors, you're not offering it in general to the general public, then you might be exempt from the registration requirements of the Securities Act. So it's not the number of people involved in the sale, it could be many, many people, but it's the sophistication of the investors. So that's the basic contours, but if we want to get into a little bit more detail, the SEC enacted a regulation called Regulation D, which provides a specific categories of transactions that are going to qualify as private placements. So it enables transactions that fit within specific rules to be automatically exempted. And it does it by creating a concept called accredited investors. Now, an accredited investor is institutional investors, people with over $1 million in net worth, venture capital firms, trusts with assets over $5 million, and directors and executive officers of the issuing company itself. So again, that's the sophisticated investors that I was talking about. And so under Rule 504 of Regulation D, if the aggregate price is less than $1 million, then that's exempt. Rule 505, if the aggregate price is less than $5 million and the number of purchasers is fewer than 35, not counting the accredited investors, you could have an unlimited number of accredited investors, then you're under Rule 505. If you're under Rule 506, there's no dollar limitation, but allows only exemptions when there are less than 35 people, excluding accredited investors, and all of the people have to be sophisticated. So again, the idea is that it's only going to be exempt from the basic securities law registration requirements if you're offering to a small number of people and most of the people you're offering to are sophisticated investors in some form or another. So the Securities Act essentially regulates the issuance of securities. The Exchange Act regulates all other aspects of securities transactions. That's after they've already been issued. So it'll regulate things like fraud, it'll regulate the stock exchanges, it'll regulate various markets. Any market where people are buying and selling securities are going to be, is going to be regulated under the Exchange Act, and also individuals who assist investors with trading activities. Every company that issues shares to the public consistent with the Securities Act is going to be covered under the Exchange Act. Every company with securities registered on a national securities exchange is covered. Every company with assets in excess of $5 million and at least 500 shareholders is covered, and any other company that voluntarily decides to register. And a company that's subject to the Exchange Act is called a reporting company, and that's because the Exchange Act requires that a company file periodic reports containing financial and other materials. That's known as a 10-K report annually, a quarterly report known as a 10-Q, and other sorts of reports all along the way. The Exchange Act also regulates how you solicit shareholder votes, or what are called proxies, by these companies. And it requires that companies issue information statements to investors whenever they solicit proxies, known as proxy statements. What are proxies? Proxies are the way you would designate that somebody can vote for you on your behalf without you having to go to a shareholder meeting. It's a way for you to vote by remote. The Act also regulates what are called tender offers, offerings made to purchase all or a portion of the shares of a specific company. So that's if one company wants to acquire another, that tender offer is regulated under the Exchange Act, and also has certain reporting and other requirements on anyone who wants to engage in a tender offer. The Act also prohibits what are known as control persons, which are directors, officers, and owners of companies, from acquiring what are known as short swing profits. Short swing profits are when a control person makes a profit from purchasing and selling her shares within a 6-month period. And so it's essentially a way of protecting against insider trading by people who have control over the company. And there are separate insider trading rules. Section 10B and Rule 10b-5 prohibit securities fraud. Securities fraud involves the following elements: a misstatement or omission, which constitutes an affirmative misrepresentation; a failure to make statements necessary for other statements not to be misleading, half-truths basically; or an omission when there's a duty to disclose. In addition, materiality, which means it's got to be whatever it is that you didn't disclose or you made a mistake about, has to be important in that it would make a reasonable investor consider the statement or omission in making a decision about a securities transaction. There has to be a scienter requirement, which means, as we discussed earlier, there needs to be intent to deceive or defraud, and there needs to be reliance, which means that you need to have relied on the information in having the market operate. But generally that's presumed, because if stocks are traded in an active securities market, there's going to be reliance on whatever statements are made, and then we look at damages and so forth. So courts have interpreted the Exchange Act to prohibit that kind of fraud, and also to prohibit insider trading, which is trading on the basis of material information that's not available for the public in general. Now we're going to turn to antitrust laws. Now, a trust refers to a group of corporations or businesses that combine together in order to enhance their economic strength and market power. And trusts are problematic because if you've got a group of corporations that combine together and there are fewer and fewer and fewer of them in a particular field, then not surprisingly, they can then coordinate better, control the market, potentially raise their prices, lower their services, and create a monopoly. And the monopoly can dominate an industry and cause harm to consumers. And harm to consumers is really what antitrust law is focused on. It's not about whether it's somehow unfair to other companies in the field. The question always is, will the combination of these companies, or will the way these companies are coordinating with each other tend to hurt consumers over the long term? And that's always the issue in antitrust law. And the antitrust laws are generally regulated by the Federal Trade Commission or the FTC. In 1890, Congress passed the Sherman Act, which is the basic antitrust act, and it prohibits agreements among corporations that would restrain trade or create monopolization in an industry. And when examining if an agreement violates the act, courts apply what is known as the rule of reason. So the question is, if two companies do something, create some sort of an agreement, the question is, did that agreement have a legitimate business purpose? Was it reasonable? Was it economically efficient? Did it make sense for some business reason? Or is the only way we can explain it that it is in some way restraining free trade and therefore hurting the market? Now, there are some actions, however, that are deemed to be per se or automatic violations of the Sherman Act. And those violations relate to what are known as horizontal agreements. And that refers to transactions between businesses that are in competition with each other. And they significantly reduce competition, right? Because you could create an agreement between competitors to set prices on products. That's called price fixing. That's per se illegal under the Sherman Act. You could also create production quotas. You could all decide you're only going to produce a certain number of some product. That will have the tendency to drive up prices, which again will hurt consumers, per se violation of the Sherman Act. Or group boycotts. So if a group of companies in an area all say, we're not going to do business with so-and-so in order to force that person to pay higher prices, then that again would have the tendency to raise prices for the product generally and hurt consumers. And then finally, dividing up the market. So if you split up geographic areas in order to eliminate competition in those areas, that again will be a violation of the Sherman Act. Now, you could imagine instances where there is a division of the market geographically where it's not an antitrust violation. So for example, if you're in a city and there are a whole bunch of pizza delivery companies, and each pizza delivery company only delivers within, let's say, a 5-block radius of their store, and therefore none of the pizza companies happen to overlap with any of the others, that's a geographical splitting up of the market, but it's likely not done for anti-competitive reasons. It's likely done because, I don't know, the pizza delivery bicyclists can't bike more than a certain number of blocks efficiently or quickly. And so that would not be an antitrust violation because it's not done to divide up the market in order to drive up prices. Now, those are horizontal agreements, agreements across companies. But there could also be vertical agreements, which are agreements between buyers and sellers. And their price-related agreements are also per se illegal. But most other agreements require court scrutiny using this rule of reason. Now, there are several types of vertical agreements that might raise antitrust concerns. So there are tie-in agreements whereby a seller agrees to sell one product to a customer, but only on the condition that the customer also purchases another product. So bundling together multiple products can potentially be a violation. Now, bulk discounts, however, are fine. So again, it depends on how it's done. Exclusive distribution agreements are potentially problematic. So if you have an exclusive right to manufacture a product within a given area, that might be problematic. An exclusive dealing agreement where there's an agreement that requires a buyer to resell products but only to a specific manufacturer. and so that may be problematic. And price discrimination. So if you are charging different buyers different prices for the same product, that can also be a problem. And so we'd have to look at whether that price discrimination has a negative impact on competition. If it does, it would be a violation of what's called the Robinson-Patman Act. There's also a thing called the Clayton Act, which regulates business combinations with regard to mergers and acquisitions that may reduce competition or create a monopoly. Section 7A of the Clayton Act is called the Hart-Scott-Rodino Act. And so if two corporations want to merge together, they have to file what's called a Hart-Scott-Rodino filing, notifying the Federal Trade Commission and the U.S. Justice Department that they want to engage in a merger, and then there will be a long investigation where the FTC and the Justice Department will look and see whether the merging of these two companies will, on the one hand, increase efficiency and therefore be better for the consumer by lowering prices, or on the other hand, reduce competition, thereby raising prices and thereby hurting consumers. And again, that's always the question for antitrust law.